Otherwise, we have
two judgments which will be pronounced tomorrow.
But these are all judgments which I had the honor and privilege to author with the able guidance of my Lord the Chief Justice and my learned brother, Justice Manoj Mishra. So that is why I'm a little nostalgic about this. And this is your matter, right? Having heard the learned counsel appearing for the parties and having gone through the materials on record, following questions call for our consideration. 1. Whether there is an error apparent on the face of the record for the purpose of entertaining the review petition. 2. If the answer to the aforesaid question is in the affirmative, then whether the exposition of law propounded by this court in Canon India as regards the power of the DRI to issue show cause notices would be said to be the correct statement of law. This would entail addressal of the following questions. A. Whether officers of DRI are the proper officers for the purposes of Section 28 of the Act 1962. B. What would be the extent, scope, and domain of Section 6 of the Act 1962, vis-a-vis Section 2, subsection 34, Section 3, Section 4, and Section 5 of the Act 1962, and whether an entrustment by the central government under Section 6 of the Act 1962 is mandatory to empower the officers of the DRI for the purpose of issuing show cause notices. C. Whether the power under Section 28 can be exercised only by someone who is empowered to exercise the power under Section 17 of the Act 1962 for the goods in question. In other words, how best the meaning of the expression proper officer should be construed for the purposes of exercise of functions under Section 28. D. Whether the proper officer in Section 28 must necessarily be the same proper officer referred to under Section 17 of the Act 1962. If no, whether the use of the definite article the in the expression the proper officer in Section 28 is in the context of that proper officer who has been assigned the powers of discharging the functions under Section 28 by virtue of powers conferred under Section 5 of the Act 1962. E. Whether issuance of show cause notices followed by adjudication under Section 28 of the Act 1962 is an administrative review as held in Canon India or a quasi-judicial exercise of power under administrative. Whether the introduction of Section 28, subsection 11, whether the Validation Act of 2011, which retrospectively validates the show cause notices issued under Section 28 with effect from 6/7/2011, is discriminatory and arbitrary for not curing the defect highlighted in Syed Ali, and therefore is violative of Article 14 of the Constitution of India. Whether the judgment delivered by the High Court of Delhi in the case of Mangli Impacts expounds the correct interpretation of Section 28, subsection 11, and whether Section 97 of the Finance Act 2022 retrospectively validates the show cause notices with effect from 1/4/2023 is manifestly arbitrary and therefore violative of Article 14 of the Constitution of India. These are the issues which we have highlighted. Section 17, read with sections 46 and 47 of the Act 1962 respectively, deals with the assessment and reassessment at the first instance, that is, upon entry of the consignments and part payment, non-payment, or erroneous refund. Keeping this statutory scheme in mind, we are unable to subscribe to the view taken in both Syed Ali and Canon India that the vesting of the functions of assessment and reassessment under Section 17 is a threshold mandatory condition for a proper officer to perform functions under Section 28. In fact, this is an error apparent on the face of the record. This scheme does not flow from and confusion due to the potential for multiple proper officers exercising jurisdiction under Section 28. We find that such apprehensions of misuse are unfounded, considering that no substantial empirical evidence has been brought forth by the respondents in this case to support such a view. Regardless, the parameters under Section 28 cannot be reduced to an administrative review of assessment, reassessment done under Section 17. We are conscious of the fact that Section 110AA of the Act 1962, which has been introduced by the Finance Act 2022, stipulates that the show cause notice under Section 28 of the Act can only be issued by that proper officer who has been conferred with the jurisdiction by an assignment of functions under Section 5 of the Act 1962 to conduct assessment under Section 17 of the Act in respect of such duty. However, we are of the view that the introduction of Section 110AA doesn't alter the statutory scheme of Section 17 and 28 of the Act 1962 as it stood prior to the introduction of Section 110AA. The legislature, in its wisdom, may introduce certain new provisions, keeping in mind the exigencies of administration and taking into account the evolution of law. However, this would not by itself mean that the procedure which was being followed prior to the introduction of such changes was incorrect or in contravention of the law. The legality and correctness of an action has to be judged based on the statutory scheme prevailing at the time when such action took place, and incorrectness or invalidity cannot be imputed to it on the basis of subsequent changes in law. Seen thus, the contention of the respondents that Section 110AA of the Act amounts to an admission by the petitioner on the invalidity of the legal position existing prior to its introduction deserves to be rejected. Therefore, in our considered view, the scheme of Section 17 and 28 of the Act 1962 respectively indicates that there cannot be a mandatory condition linking the two provisions, and the interpretation of this code in the cases of Syed Ali and Canon is patently erroneous. This court in Canon India, while laying much emphasis on the use of the expression, I quote, the proper officer, unquote, observed that the Parliament had employed the article the instead of a/n in Section 28 of the Act 1962 so as to give effect to its intention of specifying that the proper officer referred to in Section 28 is the same officer as the one referred to in Section 17. The court further observed that the use of a definite article instead of an indefinite article is indicative of the fact that the proper officer referred to in Section 28 is not any proper officer, but the proper officer assigned with the function of assessment and reassessment under Section 17. However, there is an error apparent in the aforesaid view. Undoubtedly, a definite article the has been used before proper officer with a view to limit the exercise of powers under Section 28 by a specific proper officer and not any proper officer. But in the absence of any statutory linkage between Section 17 and 28 of the Act, respectively, there was no legal footing for this court in Canon India to hold that the proper officer in Section 28 must necessarily be the same proper officer referred to under Section 17 of the Act 1962. As we have discussed in the foregoing parts of this judgment, the statutory scheme of the Act 1962 necessitates that a proper officer can only perform specific functions under the Act if he has been assigned as the proper officer to perform such functions by an appropriate notification issued by the competent authority. Seen thus, it becomes clear that an officer of customs can only perform the functions under Section 28 of the Act 1962 if such officer has been designated as the proper officer for the purposes of Section 28 by an appropriate notification. The use of the article "the" in the expression "the proper officer" should be read in the context of that proper officer who has been conferred with the powers of discharging the functions of Section 28 by conferment under Section 5. In other words, the proper officer is qua the function or power to be discharged or exercised. Thus, the definite article "the" in Section 28 refers to a proper officer who has been conferred with the powers to discharge functions under Section 28 by virtue of a notification issued by the competent authority under Section 5. In other words, the use of Article